Hello, everyone. I am Kip Odell at Kent District Library, and we are very glad you're with us this evening for a program, again, with our friends from Legal Aid of Western Michigan. We've been doing a monthly program with them, super informative and great. We're happy to do that again tonight. We are still doing, Kent District Library is most of our programs online, and you can find those on our website, kdl.org. Click on the events link, and you can see all of our events that we have for all ages going on all of the time. And a lot of adult programs are on Wednesday and Thursday evenings, so make sure you look for those as well. So I'm going to add to the stream Bethany. Hello, Bethany. How are you?
Good. How are you, Kip?
Good, thanks. So I'm going to turn it over to you.
So my name is Bethany Spencer. I'm an attorney at Legal Aid of Western Michigan. I'm in the Grand Rapids office of Legal Aid, and we are so excited to partner with the Kent District Library for tonight's program. So thank you again for having us, Kip. Over the next half an hour or so, we are going to do just exactly as the program title says and talk about 7 of the most frequently asked family law questions that we're encountering today. Some of the topics that we are going to cover are going to include domestic violence issues, general divorce kinds of questions, and custody of minor children questions. If you have questions during the program, you can write those comments and questions in the Facebook or YouTube box, but please remember to keep those questions general because we cannot answer or we don't want you to share any personal details or information. Now, before I turn this over to our first presenter, I want to do 2 things. In typical legal fashion, I want to talk about the fine print here. So while we are excited to offer some general tips and advice, this does not constitute legal advice for you. We're providing tips and resources, and we only offer legal advice in one-on-one private conversations. That's it. That's all the fine print here. One more thing that I want to discuss with you is a general resource that you can use at michiganlegalhelp.org. This is a great place to get information to learn about the topics that we are discussing tonight. It is also a fantastic resource to assist you in representing yourself if you are in the middle of a legal matter. So starting off here, I'm going to introduce you first to our other 2 presenters. We have Dan Borton. He is a staff attorney in our Holland office, and Brooke Wilsner is a staff attorney in our Grand Rapids office who works for the Crime Victims Legal Assistance Project. Let's get to the questions. We're going to start with Brooke on questions 1 and 2 about legal issues confronting survivors of domestic violence and some resources to help you stay safe.
Thank you, Beth. So question 1, I'm experiencing abuse and I need protection. What can I do? Well, first, you should really be thinking about creating a safety plan, which is essentially a personalized and practical plan to help while you're in an abusive situation, to prepare for when you're leaving that situation, or how to deal with things after you've left. One important tool that you can utilize is a personal protection order, otherwise known as a PPO, which is a civil court order that is designed to prohibit behavior by a person directed at another person, which would, in most cases, otherwise be legal. A PPO has criminal penalties, and it's meant to protect the petitioner from threats of abuse or abuse and harassment. There are 3 ways to file for a petition for a PPO in Kent County specifically. There are no filing fees associated, and you can file actually in any county in Michigan, regardless of your residence. And that may be important if you would like to keep your address confidential, which the PPO would keep your address confidential regardless. But in case the respondent could realize what county you're in, you might want to think about using a different county's PPO for that extra layer of protection. You can file for a PPO in 3 ways. One is through the local courthouse's PPO office, which they have computers set up for you to fill out forms to generate. You can also find those same forms at michiganlegalhelp.org, or you can use a website called Turbo Court to go through the process of having your petition and your PPO statement of facts generated for you to file in person or by email. When you fill out your PPO statement of facts, it's really important to be as specific as possible. You want to go with the most recent event that has happened. Try to keep your statement in a chronological, linear order. It's helpful to make it more of a narrative, really tell this story to the judge, who may need some context about why this PPO should be granted. It's also important to remember that your statement will be in a public court file and that your abuser will be able to get a copy of that file, to get a copy of your PPO. So once you've filed your petition, the judges in Kent County will grant or deny your petition on an ex parte basis, which means they have 24 hours to decide if your PPO should be granted or it should be denied. If it's denied, they have to state specifically the reasons why it's denied. If it's granted, the PPO will prohibit certain behaviors that from the respondent that are enforceable once the PPO has been entered. However, the respondent must be served with this PPO, and the respondent will have an opportunity, once served, to object to the PPO. If the respondent files an objection, there may be a court hearing where a referee will decide whether the PPO should be upheld, set aside, or whether a further trial should be held in order to grant or uphold the PPO. In most cases in Kent County, the PPO is often valid for at least 6 months. You can also file an extension that could extend it for even longer. There are 2 great resources here in Kent County for victims of domestic abuse. And the first one, of course, is the YWCA, and that website is ywcami.org, or there is Safe Haven Ministries, which is safehavenministries.org. And I would really, recommend those 2 great advocacies. That moves us to our second question. What are the different types of PPOs? So the first one, and really the most common one, is a domestic PPO, which is a PPO against someone with whom you have had or had a domestic relationship. For example, someone that you dated, someone you lived with, you were married to, or someone who is a parent to your child. The second one is a non-domestic stalking PPO, which is a PPO against someone you do not have a domestic relationship, who has stalked or harassed you on at least 2 specific occasions that were non-consensual. And the third is a non-domestic sexual assault PPO, which is a PPO against someone you do not have a domestic relationship, a domestic relationship with, who has sexually assaulted you or threatened to sexually assault you. Or this PPO could also be against someone who has given obscene materials to minors. That is all. Thank you.
All right. That takes us to question 3, which is one that I'm going to cover with you. So the question is, how should I prepare to file for divorce? And I'm going to talk about this in a general sense, not specifically related to a divorce with children, but just really any divorce. So the first thing I think that Brooke covered is if there is domestic violence in your relationship, or if you are concerned that there could be domestic violence at the point that you filed for divorce, because we've seen that is typically, it can be a situation that is escalated when one spouse files for divorce. To go through those safety planning resources, contact a local domestic violence organization such as the YWCA, Safe Haven Ministries. I think there's a couple in Ottawa County where Dan practices. I don't know if you can help me with the names there.
What, Resilience? We do have Resilience available, and Sylvia's Place as well.
Okay. So those are great organizations that can help you put together safety plans to prepare you if things should escalate at the point that you file for divorce. The next thing is to start gathering documents. So these are, there's going to be sort of the ideal way of doing this, and then the realistic thing might be that you don't have access to everything, and that's okay. But try to get access to what you can when you can. Important information to have on hand would be things like your credit report. Right now, a thing that has kind of happened with the pandemic is that everybody has free access to weekly credit reports. So it used to be that you could pull a credit report for free once a year. You can now do it weekly through, we recommend annualcreditreport.com. This is actually a free way to do it. And you don't need credit scores. That's not what's important. It's helpful to know, what your debts are, and who's on what debt. The other thing that's important to get is something like a tax return. If you can gather the last 3 years of tax returns, this is very helpful to figure out what everybody's income was, which is helpful in terms of figuring out spousal support or child support, and also to kind of get an idea of what assets might be out there that you're not even necessarily aware of. Another thing that is helpful to get are retirement account statements. Retirement accounts can be divided in a divorce through an order called a qualified domestic relations order. But it's helpful to know, again, what is out there, what are the retirement accounts, what are the balances that are on these accounts. So to start putting that information aside, and again, thinking about safety. Sometimes collecting this information might just be taking a picture of it and saving that on your phone so that you're not actually removing documents from where they were. It's also helpful, again, to collect bills and put together a budget, which is the next thing. So you need to be able to have a budget to know if you're making a claim for spousal support, for instance, or what used to be called alimony, how much you're asking for. What do you actually need to cover your monthly bills and expenses? It's also helpful to start thinking about what assets and personal property you have that you may want to divide in the divorce. Oftentimes we get into situations where if one spouse leaves the house, then it's easy to forget what you had in the house, and suddenly you're put in a position of saying, what do you want from the house? Well, if you're not in the house, it can be hard to think about that and to realize what was there. So to start putting together a list of that kind of personal property along the lines of coming up with that property information can be also looking at values. So starting to put some of that groundwork in place to look at how much is our vehicles worth when you have access to all of the vehicles, and what is the amount that's owed on the house versus how much is it worth now. So a good free way to do this is to contact a realtor about a comparative market analysis, which gives you an idea of if your house was listed for sale today, how much could it be listed for? And then also just to kind of start thinking about goals and listing them out. What, at the end of the divorce, if you had your way, what would happen? How would things be divided? For instance, do you want to stay in the house versus having the house sold, or having the other spouse stay in the house and buy you out of your equity? Do you want to pursue exclusive use of the home during the divorce? Which means you're asking the court to allow only you to stay in the house and to have your spouse be removed from the house. Thinking about long-term goals like minimizing debt and which assets you'd like to keep. So to really kind of start thinking and planning if you have the time to do that before you ever even file. Next, we're going to turn to the actual divorce process and how that filing process works. The first thing in initiating a divorce is that filing. So after all the planning comes the filing. Documents that are filed in every divorce are things like the summons and complaint, the complaint for divorce, and then additional paperwork is filed if there are minor children involved. Getting access to that paperwork in Kent County, there's a legal assistance center on the 5th floor of the courthouse, and they can help give you the forms that you would need to fill in to file the divorce. You can also go to Michigan Legal Help to get the forms to file for divorce. Michigan Legal Help, as we mentioned before, is a great resource if you are representing yourself to generate the paperwork, because the way that it works is you fill in all of the information and then it populates that information into all of the forms that you need, not only to file the divorce, but to also finish the divorce. Once the divorce is filed, then you'll have to think about how serving, or how you're going to serve the other party. Serving the other party means actually getting the paperwork that you have in their hands in one way or another. The way that service happens is by somebody who is over the age of 18 handing the paperwork to the other party. That's called personal service, and that person cannot be you. So somebody over the age of 18 that is not you can hand the paperwork over. You can also use what's called restricted mail through the U.S. Postal Service. And what they will do is when they deliver the mail, they will have the person that is receiving it actually sign for it. This is a little tricky at times if somebody's not being cooperative, because they either have to be home when the mail arrives or be willing to go to the post office to sign for it. And if they don't want to do that, then that's not going to be a good way to serve it. The other way is to hire a process server, and you can search in your local area. There are lots of professional process servers that will handle this for you. After the person is served, if there are minor children involved in the divorce, and even if there, I suppose even if there aren't, you'll have an opportunity to file what's called a motion for temporary orders in Kent County. And this is an opportunity to get an initial order regarding custody, parenting time, child support, things like exclusive use of the home, payment of marital bills, maybe even temporary spousal support, to kind of get those immediate needs addressed in that motion for temporary orders. Now, as it concerns children, there are other counties have different processes that are used to address that. So there's a new process called a FIGC, which is a Facilitated Information Gathering Conference that's used by a number of counties. And this involves kind of getting together with a representative from usually the friend of the court to talk about what the temporary custody, parenting time, and child support arrangements are going to be. And then they will issue a recommended order for that. After that temporary process is kind of over, then you'll have an opportunity for what's called discovery. And this is an opportunity to get information exchanged between the parties. Recently, there was a change that requires participants in a divorce to exchange certain financial information. Additional information can be sought through the exchange of requests to produce, interrogatories, that are written down for the other party to answer, and requests to admit. Subpoenas can also be sent out to obtain additional information from people who are maybe not parties to the case. So as an example, a subpoena could be sent to the other party's employer to get information about their income or retirement accounts. And you can also send subpoenas to banks to get bank records and a variety of other kind of options. After discovery, in most cases, mediation will get scheduled. There is an exception to this because every mediation is going to be they'll be called a domestic violence screening. So if there is domestic violence in your relationship and you do not feel that it is safe to engage in mediation, you will not be forced to. If you go to mediation, you can enter into a settlement that allows you to resolve all or even just some of the issues in your case. If you are not able to settle your case at all, then a trial will be scheduled. At a trial, typically the parties to the divorce will testify, evidence will be introduced, and third parties or experts could also be called to testify. The topics that would be covered at a divorce include the division of assets and debts. You can have a conversation about the issue of fault, although that's only relevant to potentially varying how assets and debts are divided. And then child custody matters, custody, parenting time, and child support. Speaking of child custody matters, for our next two questions, we're going to turn to Dan to discuss that.
All right, thank you, Beth. So my name is Dan Borton. I'm one of the attorneys here at the Holland Office of Legal Aid of Western Michigan. And one of the questions that I often get is, what's the difference between legal and physical custody? And describing physical custody is a little bit easier because most people know that the child is actually sleeping in a house, and that's usually what's considered the physical custody, where the child sleeps, where he keeps his clothes, where he goes to school. And so the physical custody is a little bit more apparent, more easier to describe. However, the legal custody is a little bit more complicated, and that's because it deals more with issues that are decision-making authority. And so having legal custody really means that you're able to make various important decisions about the children's lives, including like where they attend school, religious instructions, medical decisions, if they're going to get braces or not, and many other important decisions that a legal person who's an adult would be able to make, but a child is just not capable of doing that because they don't have the legal authority. And so parents do that. Now, normally when there's a marriage and a family, during that marriage, both parents participate and they usually communicate and talk to each other, and then they come out with decisions. And so when there's a divorce, most judges that I've encountered and that I've worked with, they want to keep that authority intact. They want both parents talking about it, making decisions together and communicating so that they're both involved with the children's lives. And so for the most part, legal custody is usually shared. And that's different than that's different than the physical custody, which is not always shared. However, the parties are able, on occasion, the parties may not get joint legal custody. And that's usually because the judge may see that there may be some friction, inability to cooperate, inability to talk to each other. If there's a fight every single time there's a question, or if somebody's causing disruptions on just any little thing that the other party makes, under those circumstances, sometimes the judge will give one parent sole legal custody. And what that means is that that parent will make the initial decision for the children's health, for example, or education or welfare, and that's subject to review. What that means is that if the other party is not in agreement, they can raise that issue with the front of the court's office. And the front of the court will actually have a hearing, will listen to the parties and why they want. And a perfect example would be having braces. That's a legal decision that's made by parents. And sometimes parents don't agree whether there should be braces or not. And so they'll bring that to the front of the court's office, who will then have to make a tough decision as to whether that's appropriate or not. Once that decision is made, the parents, obviously, who wanted the braces will be happy. But if the parent who didn't want the braces, he can also object to the front of the court's recommended order. And that would then go in front of the judge. The family court judge has been assigned to those folks in the divorce or in the custody action. And then at that point, the judge will make the final decision. Of course, there's always rights to appeal. But for the most part, it usually stops with the judge. Judges often also grant sole legal custody to one parent where there's a great distance away. So if one party lives, for example, in Detroit and the other party lives in Grand Rapids, and the children are in Grand Rapids, then sometimes what the judge will do is they'll make one parent have sole legal custody so they can make day-to-day decisions that affect the child. And so when the child is with father, sure, he can make those decisions. But because the child is living with mother here in for example, Grand Rapids versus Detroit, that distance causes it very, very difficult to have both parents making decisions. And then, of course, also in abusive situations or when there's neglect. If there's neglect and there's abuse, then most judges will have a little, just to be wary about giving joint legal custody in those circumstances. All right, the next question is also one that I often hear from parents, and that is, are parents able to agree and change parenting time orders and custody orders? And I think that I hear this very often because parents are sometimes not able to afford attorneys, and the legal practice is getting more and more expensive, as we all know. And so oftentimes parents are going to self-help centers, they're getting the forms, they're trying to increase parenting time possibly, or modify custody orders. And so the question is, can the parents do a modification of custody orders without the court involvement or without the judge's input? And that's kind of a tricky question. So I'm going to say possibly. And the reason I say possibly is because under our current court laws, the court remains free to exercise its discretion on issues of child custody and child support. And so they never have, as opposed to property issues where the parties can agree to property and the court cannot override that agreement. Under custody issues, the court can look to the best interest of the children and can actually override the parent's decision. So even though the court has the ability to maintain its discretion, a lot of times what happens is that they want the parties agreeing to a certain set of parenting time rules or custody orders. And so what they do is they do allow parties to agree as to custody and parenting time. And if they believe it's in the best interest of the child, then they endorse that and they accept the agreement that's been resolved by the parents. And so I find that for the most part, parents do and are able to prepare what's called a stipulation. And in that stipulation, they can modify existing court orders or they can enter into new court orders regarding custody. And those will, most of the time, if it's in the best interest of the children as deemed by the court and by the judge, then those will be followed. Of course, as I stated earlier, there are some complicating issues with this factor or with this issue, and that is because under custody law, if you modify a custody order, it may prevent you from actually filing a custody action. And I'll explain why. And that is, under Vedvarka, in order for you to file a new custody order, you must show a change of a proper cause or change of circumstance. And if you're stipulating to a new order, that means that your new order becomes effective as soon as you stipulate to it and as soon as the judge signs it, which means that you cannot look backwards. And so what's interesting about that is that in order for you to show a change of circumstance or a proper cause, you can only go back as far as the last order that's been entered. And so if you've just entered a new order with your opposing party, which is either spouse, then you're not going to be able to go back in time and look at the changes that have occurred. And so it may actually prevent you from filing a new custody order. So you want to take into consideration that before you enter into a stipulation in order, changing custody or changing parenting time, because that way actually may prevent you from actually filing something such as a change of custody or a change of parenting time issue. Of course, the court's also going to look at the best interest factors, and they will review the best interest factors in deciding whether there should be a change of custody, altogether. I think that answers or that deals with that question, and I think that ends my time with regard to the question. I hope that's answered that.
Thank you, Dan. So that was all of our questions on domestic violence, divorce, and child custody. We had one more question, our question 7, and this is kind of a topical question to deal with, that if you're going through a divorce and your spouse won't share stimulus payments, what do you do? And I think this question is written maybe even more specifically than it needs to be. I think it probably could be even more general in saying that if your spouse or former spouse received a full stimulus payment, including your share of it, based on a previously filed joint tax return, what do you do? And we have limited guidance from the IRS on this issue. And one of the places that we've kind of looked to is the filing instructions on the IRS 1040 form for the year 2020 taxes. And that says that any payment that is received by a spouse based on a previously filed joint tax return would be treated as if it were paid to each of the spouses or former spouses individually. And so we have, at this point, no reason to suspect that the most recent rounds of stimulus payments would be treated any differently. But again, this is an issue where there's some limited guidance from the IRS. So there's certainly some question marks here. So our opinion at this point is that likely the best way and potentially the only way to address this issue is through the family court. So certainly this is the way to address it if you are in the middle of a divorce and that's not yet finalized. You would need to file a motion to divide the stimulus payment through the divorce case. But I think that at this point, based on what we know, probably even for post-judgment divorces, so that is after your divorce has already been finalized and a judgment of divorce has been entered, that likely the family court will be your only remedy to address one spouse getting the entire stimulus payment. And I think that covers our questions for today. We have our recap here. I don't know if there are any questions that are available in addition to what we've already talked about.
I know we didn't get any questions.
All right. Well, I want to thank KDL for their partnership with us. We have, if there are issues that you are experiencing and you think that you would qualify for assistance from Legal Aid of Western Michigan, you can see our phone numbers here for contacting us based on your county of residence, as well as the different kinds of legal matters that we cover. You can certainly call us and we will do a screening to see if yours is an issue that we can help with. And I think that wraps it up for us. Thank you so much.
Thank you.